And okay. And welcome everybody to the Public Justice Center's Justice for Breakfast. And this morning we're going to have a discussion on the right to counsel for tenants, a growing movement. And our presenter this morning is Maria Roumiantseva. And most of you who have been or heard about the National Coalition for a Civil Right to Counsel have, of course, seen John Pollack, the facilitator. We hired Maria to also work at the coalition. Let's see, over a year ago now, Maria, right? Almost 2 years, it feels. And anyway, Maria will be doing the presentation this morning. And with that, I will turn it over to her. Maria?
Yep. Thank you, John. So let me just make sure that everything's right. Okay. My name is Maria Roumiantseva. It's such a pleasure to be here with all of you. I wasn't expecting so many people to join us on a Wednesday morning at 9 o'clock, but I think it just speaks to how exciting the conversation around the right to counsel for tenants is right now, and how much really of a growing movement it is. My name is Maria Roumiantseva, and I am a staff attorney at the PJC, licensed right now only in New York, but also the associate coordinator for the National Coalition for a Civil Right to Counsel. And I joined, as John just briefly mentioned, just to give you a little snippet about myself, I joined in February of 2020. So just as the pandemic was kind of gearing up, I joined NCCRC and PJC. And prior to joining NCCRC, I did direct client representation. I practiced in New York State for 6 years, first at the Legal Aid Society, doing child welfare work. I was an attorney for children for a number of years in Brooklyn, New York, and then moved up to Legal Services of Central New York, where I did eviction defense, so represented low-income tenants facing eviction, and also practiced in a variety of other civil areas. So I have that direct client representation experience, but now do a lot of the kind of broader, more policy-based work that we do at NCCRC. So thank you again, and I'm really excited about the conversation we're going to have. We're going to have some time for questions and answers at the end, and I'm really looking forward to learning from all of you and hearing from all of you. So I'm not sure how familiar everyone is with NCCRC as a project of the PJC, and so I wanted to give just a little bit of context for us, for the coalition, for the work that we do, and just a little bit about our mission and kind of the structure, the support that we offer jurisdictions that we work with. So NCCRC, the National Coalition, was founded in 2003, and we are a project of the PJC, but we're a little bit of a unique project because our work, the focus of our work, is really national in scope. Our coalition is really broad and also national in scope. So we have over 600 participants and partners in 41 states, including Maryland, of course. And those participants and partners are made up of individuals who are really supportive of or actively working towards establishing a civil right to counsel in a variety of civil legal proceedings. So it varies in subject areas, and I'm gonna run down some of those subject areas in our presentation this morning. Those individuals vary. They could be lawyers, organizers, advocates, academics, just people that are supportive and working towards a right to counsel. The mission of our project of NCCRC is really to support and coordinate advocacy that expands the recognition and implementation of a right to counsel for low-income people in civil cases that involve basic human needs. And so when I talk about basic human needs throughout this presentation, what I'm really referring to are, as just for example purposes, things like shelter, physical safety, sustenance, health, child custody. Those are basic human needs that are implicated in a variety of civil legal proceedings across the United States every single day. And our job is really to advocate for litigants to have attorneys in those proceedings to help them navigate those proceedings. How we work varies from jurisdiction to jurisdiction. We work in all 50 states, and it really depends on what the jurisdiction is doing and what they intend to do with regard to the civil right to counsel. We do not do client representation, but we work with the advocates and stakeholders that are really working to establish the right to counsel in their jurisdiction. And so our work really varies. It could be technical assistance and guidance for one jurisdiction where we really talk through what a right to counsel might entail. And then working with another jurisdiction, we might be offering oral or written testimony and supporting their legislative advocacy towards a right to counsel. In other jurisdictions, we sometimes submit amicus briefing in cases that are pending or coordinate amici to join in on a single brief. And we do a lot of public advocacy and awareness, submitting recommendations to federal agencies regarding the right to counsel, presenting at conferences. John always kind of very frequently speaks with the press. So you'll see his name and the National Coalition in a lot of articles, particularly with regard to the eviction right to counsel right now. And our main kind of task, and what I really want to point you to, is we as a kind of unique project at the PJC also maintain a separate website from the PJC. So you'll find some information about the National Coalition on the PJC's website, but you'll also find information and kind of our clearinghouse of information with regard to civil right to counsel on civilrighttocounsel.org. And so that's where you're really going to find the information that we maintain. For our presentation today, what we're going to be talking about, I just want to give you some goals, an overview of what it is that I'll be talking about. And again, there is a period for questions and answers towards the end of our presentation today. So we're going to go over the civil right to counsel kind of more generally. We're going to really hone in on the right to counsel for tenants, the movement that's been growing, where legislation has been passed, where laws and ordinances have been enacted, and also where there's some considerable movement and what we're expecting kind of for 2022. And then lastly, I'm just going to touch just to give you an idea of really how the civil right to counsel is growing in a variety of subject areas. I'm going to be going over some additional growth in other civil legal proceedings. So let's get started, I think. It's time. So what are we talking about when we talk about the right to counsel? The right to counsel means that there is a governmentally recognized, which means established in the law, and governmentally kind of funded and provided access for a person to have representation in a civil legal proceeding, or in a legal proceeding, as we'll discuss. There's a bit of a criminal civil divide. And so what we mean by governmentally recognized, meaning that it is established in the law. It's found either in the case law, a court has found it within the state's constitution, for instance, under the Due Process Clause, or it's been enacted in legislation by the legislature of that state, or by even a smaller body, so such as a city council, as we'll discuss with the tenant right to counsel. The civil cases that we really focus on for our job, as I mentioned earlier, really are those that deal with the basic human needs that are at stake for people in those proceedings. And so we're talking about shelter, we're talking about evictions, we're talking about physical safety, so domestic violence proceedings, for instance, we're talking about health, we're definitely talking about child welfare work and child custody. And those are the proceedings that we kind of really focus on. But if you take a look at our website, you'll see that the subject areas that we touch on and that we accumulate information about really just run the gamut. It's all types of civil legal proceedings that are implicated here. I wanted to share a bit of a quote about the right to counsel. So this is found in an article that was written by Andrew Shearer, who we work really closely with at the New York Law School. And this was prior to the enactment of the right to counsel for tenants in New York City. And so it really goes into, it describes what a right is and why we are really advocating for a right to counsel. Because it means something a bit different than just funding legal services to a greater degree or providing more attorneys to provide representation. It really stands apart from those types of programs because it is something that a person has a claim to. It is something that they have a right to. So when we talk about the right to counsel, it really is different from programs that are privately funded. It's different than programs that are established for a time-limited duration. So things like studies or pilot projects that are trying to really look at how representation functions within a civil legal proceeding and whether it works. Oh. My computer wasn't letting me switch back and forth. When we talk about the right to counsel, it also is, it's very important to consider it as part of the access to justice continuum. And so there has been, for a very long time, for decades, much written about and much talked about the access to justice gap, about the justice gap that exists within civil legal proceedings, specifically the civil justice system specifically. And the access to justice continuum kind of incorporates all of those efforts that advocates are reaching for and are making in order to rectify some of the very problematic, very large problems that we see within the civil justice system. And so the access to justice continuum really spans the variety of efforts to change that system. And it could be something like changing the way that forms are written in court and the way that they are provided to pro se litigants so that pro se litigants can advocate for themselves, all the way up to a state-funded right to counsel program where the state really takes ownership, has a stake in making sure that people have representation in a particular proceeding. I mentioned a bit earlier about this idea of a criminal kind of civil divide that a lot of advocates don't really or write about, the fact that it doesn't really exist. So in the criminal context, people are really familiar with the right to counsel because it's so embedded within our pop culture, and it's also really embedded within just the jurisprudence, Supreme Court jurisprudence within our laws. We understand it. It's the Miranda warnings, right? It's an attorney if you cannot afford one. It's written within the federal constitution within the Sixth Amendment. So the right to assistance of counsel for his defense is a statement that's within the Sixth Amendment of the federal constitution. And it's not for all criminal offenses, but we understand, and there's something easy about understanding the right to counsel kind of extending to a proceeding where your physical liberty is in jeopardy or where you're at risk of incarceration, where your life might be at stake. That's not the same when it comes to civil cases necessarily. The civil right to counsel is really a patchwork. And that's demonstrated in the next slide where I show you an example from our own status map, from the NCCRC's status map. But it really has developed piece by piece, really piecemeal. And so it happens through litigation, such as where a state court might find the right to counsel in a certain proceeding within the due process clause of the Constitution of that state, or within the Equal Protection Clause. It might happen through legislation at the state level or at the city level, or it might happen that the court rules in a particular jurisdiction kind of mandate or require the appointment of counsel in a particular in a particular civil proceeding. And so there's varying levels of the right to counsel, the civil right to counsel across the United States. And that's part of what makes our work really difficult, is to track kind of at the local level, at the state level, at the federal level, where right to counsel efforts are really being made. So one thing to kind of take away about the civil right to counsel is understanding that every state in the United States has a right to counsel in one or more civil proceedings, but it's not guaranteed across all civil proceedings. It's not guaranteed for all people, and it's not guaranteed in every single jurisdiction. So it's not something that you can necessarily rely on. There was a quote that John shared with me that I really took to when learning about the right to counsel, and when thinking about it. It's this idea within the civil context. It's this idea of a justice by geography. It depends on where you are, but also I think it really depends on what kind of civil proceeding it is that you're a part of, and whether you are even eligible based on the constraints within case law, or based on the constraints within legislation about what kind of litigant you are, whether you fit a particular eligibility. There's no real single source of law to reference when we talk about the civil right to counsel. And so that is why we really refer to it as a patchwork. I want to share this example. These are snippets that I took from our website. So this is an example of what we do as far as the information kind of gathering and sharing that we do on the website. As you can tell, if we look at the right to counsel for birth parents in state-initiated termination of parental rights proceedings, for instance, you could see that there's the majority of states have a categorical right to counsel, which means that there is a right to counsel if you are a birth parent who is faced with a termination of your parental rights to your child that's been brought by the state. When we look at the same kind of map, but in the context of eviction proceedings and for tenants facing evictions, you'll see that that map is, it's a lot more, the places where the right to counsel exists are a lot more sparse. The map itself is a lot more sparse. And you'll see that those on the right side of your screen, trying to figure out which screen you're seeing, which side of the screen that's on. But the tenants facing eviction map will show you, really it hones in on cities that have enacted a right to counsel, but also as you will find out through this presentation, there are also now 3 states that have the eviction right to counsel or right to counsel for tenants. For civil cases, I think this is one of my this is a really important kind of part of the conversation, is discussing the why. Why do we care about establishing a right to counsel, and why does it matter? Within the civil context, the types of proceedings are so varied, and the types of consequences that are associated with those civil proceedings are also really varied. A small claims proceeding is a civil proceeding, but so is a termination of parental rights proceeding, which has been called the civil death penalty. And yet, as we just saw on that map, there are still a few states where the right to counsel in a termination of parental rights proceeding is still discretionary. And so you don't necessarily have the right to the assistance of counsel during that termination of parental rights proceeding, depending on where you are. And the stakes can be not necessarily as high as the termination of parental rights, but just as high. You can go to jail as a result of a civil proceeding. You can lose housing. You can lose your shelter as a result of an eviction case. You can lose your vital benefits in a civil proceeding. There's civil proceedings that also implicate physical safety and also abridge your physical liberty, your ability to kind of move around in the world. So there are really high stakes and the really important consequences that attach themselves to civil proceedings. In addition to that, these cases are and can be extremely complex, both substantively and procedurally, just in the ways in which you move through a proceeding is what I mean procedurally, and then substantively just the law that accompanies those types of civil proceedings in your particular jurisdiction. And that can vary greatly depending on where it is that you are. In addition, people of color are severely overrepresented in civil cases where basic human needs are at stake. So we'll see this, a discussion of this within the tenant right to counsel when we hone in on that topic. But also the way that our current system functions, it completely underserves people of color and litigants of color. And it also underserves just society as a whole. In civil proceedings, one striking fact is that whereas one litigant will be pro se or will proceed on their own, opponents are often represented. And we can see this when we look at child welfare proceedings, where the state brings a child welfare case. So not necessarily at the level of a termination of parental rights case, but a child welfare proceeding where there's abuse or neglect that's been alleged. And the government, with all of its funds, with all of its kind of backing, will have a representative, an attorney representing that side, whereas a parent or a child might not. And this is also evident in eviction proceedings, foreclosure proceedings, where banks are regularly represented against people who do not have a right to representation or a right to counsel. And this disparity in representation really leads to unbalanced outcomes. There's a couple of statistics on this page that I wanted to share with you, because I think that they really speak to how striking the problem really is, the problem of not having representation or not making representation a right in civil cases. So 3/4 of all civil cases involve at least one unrepresented party. And when we look at the system as it currently functions, what we end up doing in civil legal proceedings is really relying on the legal aid providers and legal services providers across the country who are working tirelessly to represent people in civil legal proceedings, low-income people in civil legal proceedings, but which often have to turn away just as many people who come through the door who are eligible for their services as the people that they take. And so there's one legal aid attorney available for every over 6,000 low-income people in the United States. And that those numbers might shift a bit, but that is pretty much the standard, is that there's a severe lack of legal aid attorneys and resources, capacity in order to handle all of the civil legal problems that low-income people have, and that they will continue to have, because that's the way that we've structured our civil justice system. One study, and this refers back to the Legal Services Corporation, which conducted a nationwide study, found that 80% of legal needs of the poor go unmet, and 50% of those who are seeking help don't get it. So they are turned away from legal aid, not because legal aid services don't necessarily want to represent those people. It's because of capacity issues. It's because of funding issues. Right. Legal representation in civil proceedings really does make a difference. We're going to get into this as we discuss the tenant right to counsel more specifically. But there are documented benefits of representation, and they are all available in our comprehensive bibliography on the civilrighttocounsel.org, where we've identified all the studies and reports that kind of have looked at representation in civil legal proceedings and seen what are the benefits of having representation. So one study found that 8 to over 200 times, right? So that number, that statistic refers to represented litigants able to win their civil case, are 8 to over 200 times more likely able to win their civil case than those who are unrepresented in the same proceeding. That study comes from Rebecca Sandifer in 2015, and it was a comprehensive meta study that looked at prior impact studies. Also, represented litigants are twice to nearly 5 times more likely to prevail than those who receive the assistance of a non-lawyer advocate. And the reason that I incorporated that statistic is because it also links back to that access to justice continuum and the comments that I made about that earlier. Advocates within the access to justice kind of movement have a variety of ways in which they want to help people who have civil legal issues and who are currently unrepresented. And so one of those conversations is about, expanding non-lawyer advocacy or changing the way that forms, again, are made. So pro se court materials are functioning, changing those. What we see, though, is that the studies of representation are really consistent in showing the effectiveness of having a lawyer in those proceedings. All right. So we've kind of wrapped up the civil right to counsel, I wanted to give you a very broad overview of what it is that we're talking about when we talk about the civil right to counsel. And now we're going to hone in on the right to counsel for tenants in eviction proceedings. So on this page, what I've done is John kind of uses articles throughout his presentations to indicate just how much the conversation has really grown about the right to counsel. So in this, in the examples that I show here, there really is a conversation that is happening about the movement to establish a right to counsel for tenants. And that movement is happening, it's very local at the moment, but it is starting to grow to state levels, and it is starting to grow to more and more cities every day. When we talk about the right to counsel in eviction proceedings and the right to counsel for tenants specifically, what we're talking about is a quick, devastating proceeding that happens before COVID-19 that was happening or being filed at least 3.6 million times a year. And that's the eviction proceeding. It's this proceeding for a landlord to claim that they should have possession of their quote unquote unit back. But that eviction, although the landlord is asking for possession of their unit back, that eviction also very obviously implicates the shelter of the tenant that is living there. It's their home. It's the tenant's home that is being discussed and kind of adjudicated in an eviction proceeding. So prior to the pandemic, as I just mentioned, so 3.6 million filings. So that statistic comes out of the eviction lab, which kind of looked at or tried to look at how many filings, how many eviction filings were happening nationwide. The problem with the statistic is that it's, and the eviction lab states this in their findings, is that it very likely is a severe undercount of the actual number of evictions that are happening across the country every year. And that's because we have a very poor tracking system for eviction filings and eviction cases. We, across the country, find that court records are kept really poorly, so they don't keep their records really well, and they're really difficult to kind of obtain from the courts. that's to say that it's very likely an undercount and that there are more eviction filings that were happening before COVID-19. There are, in terms of eviction proceedings, differences nationwide. The LSC has just done a study of all of the eviction laws nationwide. So they vary in name, they vary in procedure. There can be different reasons or defenses that can be brought up within the context of an eviction. But the very true kind of constant reality is that these proceedings are quick and they're brutal. They are meant to be summary proceedings, which happen, in the context of a court case, of a civil proceeding, in the blink of an eye, right? And they also just completely disrupt the lives of the people who are living in that home. In addition, eviction proceedings we know that they disproportionately affect tenants of color. And this is due to just decades of inequality within our housing system, within our civil justice system. So communities of color and low-income women in particular are impacted the most. The Eviction Lab did a recent study where they found that Black women are more than twice as likely to face an eviction filing than white people are. And less than half of Black and Latinx families own their home, compared to 73% of white families. And so the renter population is really high. The kind of long-standing systemic inequality that's inherent to our civil justice system, and then also to the way in which we do housing in this country, to the way in which we pass wealth in this country, really put communities of color and Black women at severe risk of eviction. The consequences of an eviction are immense. I mean, evictions touch every single part of a human's life. They're well documented and they are horrendous. Not only are you losing your home, you are often losing your property. You're also often losing your community connections if you have to move out of a particular community, or if landlords in that community will no longer rent you. It accompanies, the loss of employment accompanies an eviction in many instances. There are impacts on physical and mental well-being. There's intersections with police, with the child welfare system, custody implications for children who are involved in evictions, higher use of homeless services and shelters, because we have an abysmal affordable housing kind of policy, but also infrastructure in this country. And it really, the kind of problematic part of evictions is that even if you don't get evicted, that filing, the very filing, can impact your housing stability in the future, because it might linger. It might attach itself to your name and stay on your quote unquote record in terms of finding new housing in the future. The other kind of important pandemic related piece is that there is evidence showing that there is, with higher rates of eviction, with eviction comes a greater risk of exposure to COVID-19. With the right to counsel for tenants, should have taken a sip before I started talking. And with the right to counsel for tenants, recently, so we used to use the statistic where we would say that 90% of landlords are typically represented, and 10% of tenants might be, 10% of tenants might be, 90% of landlords are represented. When we got into, when the pandemic kind of took off, John did a look. So he looked through all of the research about representation that we had access to and kind of looked at, I think it's over 20 studies. And on average, what we found is that it's a different statistic, but it is no less horrible. So 81% of landlords are typically represented in eviction proceedings versus about 3%, sometimes less, lots of times less, 3% of tenants in eviction proceedings. And this has really important consequences. So when you don't have representation in an eviction proceeding, but your opponent does, your landlord does, there are really important, significant consequences. In the District of Columbia, there were pilots running that found that tenants without counsel were twice as likely to be found in breach of lease. They were 3 times as likely to be subjected to a writ of possession, and they were 7 times more likely to wind up with a consent judgment, which they've identified, the DC pilots in writing about this, identified as less favorable than a settlement agreement. In Philadelphia, unrepresented tenants experience disruptive displacement 78% of the time compared to 5% of represented tenants. There is just that statistic alone really shows how stark the difference is when you incorporate representation into a proceeding. And in Virginia, when plaintiff success rates were looked at, so typically that would be the person that brings the proceedings, so the plaintiff. So when plaintiffs were the only ones represented, 60% of the time they were successful versus 20% when both sides were represented. So the right to counsel for tenants, what we're talking about really includes full representation. So that is the counsel follows you through the proceeding and does the most that they could do for the tenant facing eviction. So, presents defenses, if possible, asks for a jury trial if one is warranted, really conducts the representation of that tenant fully and zealously. It's also something that's established in the law. The way that it has been happening is incremental across the United States and really at the city level, as I'll show you in just a little bit. The growth is happening at a really local level. So through city council proceedings and passing local laws, passing ordinances. And also, it really refers back to when I discussed what is a right, what's a right to counsel. What do we mean by that? And it's a government obligation. It means the government has a stake in that, in the representation of tenants. So funding, for instance, is coming from the government. The government owns the right, so they feel responsible for the right. And it really, when we talk about the right to counsel, we're really talking about any kind of eviction proceeding. One of the things that's kind of less known, I would argue, is that there are these eviction proceedings that are happening at the court level, so filed in court, but there are also eviction proceedings that are basically eviction proceedings, but not happening within necessarily a court. So like administrative proceedings, for instance, that terminate a subsidized housing tenant's voucher, Section 8 voucher, or maybe their public housing. So those are proceedings which are going to implicate the access to housing, but they basically function as an eviction proceeding and can be followed up by a court proceeding that does actually evict the tenant from the premises. This is also the right to counsel. When we talk about it, it's really a part of the housing, of a larger housing kind of reform movement and a larger kind of housing justice platform, right? And so a lawyer in an eviction proceeding is only going to be able to do what the laws permit and what the laws allow. And so there are really big conversations happening about, landlord tenant law reform. And the LSC study that I mentioned earlier really took a look at what eviction proceedings look like across the United States, what those actual court proceedings and court filings look like. So let me just make sure, right, okay. We are at 9:44. I want to make sure that we have plenty of time for questions and answers. So the right to counsel for tenants, what we know about it is that it really works. And those are some of the studies I kind of referenced earlier on, but when we look at really specific studies of either pilot projects or increased representation, or even at the effects of implementation in the cities where right to counsel has passed and has been implemented for a number of years, like New York City or San Francisco or Cleveland, for instance. When we look at that, we know that right to counsel for tenants works. We know that representation does make a difference. It changes outcomes. Right to counsel changes the dynamics of a proceeding, and it also increases the likelihood that tenants are going to remain housed. It increases it betters the settlements that are come to in eviction proceedings. It doesn't necessarily change the number of settlements that come out of eviction proceedings, but it does change the terms when it's lawyer versus lawyer versus lawyer versus a pro se litigant or a pro se tenant. In Hennepin County in Minnesota, when representation was looked at, so represented tenants were 4 times less likely to use a homeless shelter. Massachusetts, we see that fully represented tenants have stayed twice as often. So they've stayed in their homes twice as often. They saved 4 times as much, and they typically pay about $600 less to landlords than those with limited scope representation. So that means counsel and advice or representation just for the eviction proceeding that's happening that day, rather than kind of the full representation that I discussed earlier. There's also studies out of Denver, which I don't have on the slide up there, but a study showed that the small number of tenants who were able to secure counsel were able to remain in their homes 70 to 100% of the time, compared to 32% of unrepresented tenants. And in Seattle, which recently passed the right to counsel for tenants in 2021, so just earlier this year, the Housing Justice Project there found that, and they're the legal services provider for Seattle, the main legal services provider, showed that 52% of represented tenants in Seattle were able to stay in their homes, compared to only 8% of unrepresented tenants. And that kind of, it just makes sense that when a lawyer intervenes, when a lawyer is helping to navigate the proceeding, they're going to be aware of the substantive defenses that might be brought up. They're going to be aware of tactics to slow down the proceedings, such that emergency rental assistance, for instance, can be given to the tenant. The tenant can apply and actually access that emergency rental assistance. In addition, we know that right to counsel for tenants really saves jurisdictions money. So the numbers that I have up on the screen for you there are from Philly and from New York, and they really have to do with the amount of money that we invest in a right to counsel in a specific jurisdiction, and how much an expected kind of benefit or savings for the jurisdiction, what that amount kind of looks like. The amount in terms of savings is really looked at by looking at how much does a jurisdiction spend on all of the effects of an eviction proceeding: homeless shelters, foster care, medical care, incarceration. When we look at all of those costs and try to think about how evictions lead to things like that, that's where we kind of look at the costs and savings. There's also, just on that one note before I move on, there's also many, many costs of evictions that we absolutely cannot quantify. So the mental and physical anguish, and also just impact that evictions have on people, and the long lasting impact that they have on people who are evicted. That's also well documented, but not as readily quantifiable. So here we are, what we all came for here. The right to counsel for tenants has been enacted now in 14 jurisdictions, which is amazing. In February 2020, when I joined NCCRC, there were 5 cities that had the right to counsel, and they were New York City, San Francisco, Newark, Cleveland, and Philadelphia. In the last, I believe starting in about October of last year, there just has been an immense expansion in the right to counsel for tenants. So Boulder joined, Baltimore City and Maryland joined, Seattle, Denver, Louisville, Toledo just passed on September 15th. They put a right to counsel on the books there. Most kind of exciting and really unexpected. I don't know if we were really talking about a statewide right to counsel in eviction proceedings when I joined. I don't remember John mentioning it, but now there are 3 states with the right to counsel for tenants. So Washington State, Maryland, congratulations, and Connecticut all have the right to counsel for tenants who are facing eviction. All of these ordinances and laws are different. So they incorporate kind of different eligibility criteria. The way that they're structured is different. Funding structures, unfortunately, are really different within some of these. They're also super different in the way that they've been passed. But the basic understanding is that there is a right to counsel now for a tenant who is facing an eviction proceeding in these jurisdictions. So when they face an eviction, when an eviction has been filed, they have the ability to ask for counsel and to find counsel, to access counsel. Typically, that's the way that they will kind of write it into the ordinance, is that it's an access to counsel. I wanted to talk a bit about New York City and San Francisco. They were one of the first couple of cities that passed the right to counsel. And the reason I wanted to hone in on them is because of the successes that they've been able to document, because they've already been implemented. So a lot of the 14 jurisdictions aren't actually in implementation mode just yet. They are all on the way to being implemented, but not necessarily fully running. The ones that we really can take a look at their success is New York City, San Francisco, and really Cleveland. So in New York City, what we know after seeing New York City's right to counsel passed in 2017, and after that, what we have seen is that 86% of tenants who are represented by counsel are remaining in their homes. The reason that on the slide I refer back to 2013 is that is when funding kind of really started to increase for representation of tenants in eviction proceedings. But what we know from increasing that representation and also the right to counsel in the city is that evictions are dropping. So eviction filings are dropping. There was a 20% drop in 2019 alone, and default judgments are dropping. Default judgments when a tenant does not attend the proceeding, for instance, and the landlord gets a judgment in their favor. Those are dropping by 34%. And right now, what New York City is really doing is trying to make sure that the word is out. Recently, there were changes to the law that allowed it to be implemented immediately across all of the all of the zip codes in New York City, so that no longer did they have to follow this kind of structured plan where they were following zip code by zip code to try to increase representation there. Now it's just across the city. And you can visit the RTC NYC Coalition, which has a really remarkable toolkit on their website, and also a documentary that I recommend watching if you're interested in looking at a film about the right to counsel in in eviction proceedings. The other kind of major success was San Francisco's right to counsel. And that right to counsel was really led by the Democratic Socialists of America. What we know from San Francisco is that it's a really interesting kind of story about how it was enacted, because it was enacted by ballot initiative rather than local law passing like in New York. But San Francisco is kind of unique because it's a huge city, but they also don't have an income limit. And so all tenants are eligible for the eviction right to counsel. The filing rate there dropped by 10%. 2/3 of tenants receiving full scope representation. So that's a full representation I talked about earlier. 67% of those are able to stay in their home. And we know that even if there is no income limit, the people who are really accessing representation and really in need of representation and benefiting from this are people who are super low income, extremely low income. Let me see if I just wanted to go over a couple of other cities that have passed the right to counsel, and then we're going to jump in to what is coming up and where jurisdictions are kind of working on it. And then we're going to jump into some other subject areas and questions and answers. So just to wrap up where the right to counsel has already been enacted. In Cleveland, which is really interesting because they were implemented during the pandemic. Within 6 months, they released a report showing that 93% of those represented avoided eviction or an involuntary move. 83% of those who were seeking additional time to move were able to get it. And 89% of those seeking to mitigate damages were also able to do so. That's with the right to counsel, which passed in 2019 and then launched over the summer of 2020. So within 6 months, the report was issued, I believe, in January of 2021. Those are the findings that we're seeing. So really, really quick uptick in representation has dramatic results for a jurisdiction. And Cleveland's right to counsel is interesting as well because they didn't have this groundswell of kind of community organizing. Their legal aid provider was really instrumental in working with stakeholders and trying to figure out the right to counsel for Cleveland. They do have a really limited right to counsel, which is limited to households with children, but are kind of, waiting or hoping to broaden that. The COVID-19 enactments have been amazing. I don't know how people got together and kind of got all of their advocacy together and all of the organizing together in order to pass it in so many jurisdictions and 3 states. It just shows how committed people are to expanding the right to counsel for tenants, recognizing that it is a really effective tool in kind of responding to the eviction crisis. Not the only tool, but a really important one. So Boulder, for instance, passed a no income limit right to counsel for tenants. It was called No Eviction Without Representation. It was also by ballot initiative like San Francisco. Baltimore was amazing and a really happy victory, I think, for PJC, which was working really intensely with the Baltimore Renters United, who were instrumental in its passage. Before the So before right to counsel, we don't have any data. Post right to counsel, it's still in the process of kind of figuring out implementation. But before that, only 1% of tenants had representation, and 80% of tenants had a potential defense to eviction, but only 8% actually successfully were able to present that defense without representation. And you see the kind of the same thing when you listen to testimony across all jurisdictions, is those really stark kind of statistics and numbers. In Louisville was really interesting and also really exciting because it was the first city in the South to pass a right to counsel. It was really unexpected, and it is funded, which I'll touch on right before I sign off, is it was funded with emergency rental assistance funds. So there are portions of ERA funds 1 and 2 that could be used to support legal services or legal representation. And those funds were used in Louisville to really to start off this right to counsel. In Louisville, you have to have at least 1 child and you have to be income eligible. But even with those restrictions, there is a right to counsel now on the books. And Toledo, of course, just passed on September 15th. The 3 states are Washington, funded with general revenue. Washington passed it earlier this year, and it has a really flexible definition of indigency to try to kind of capture as many tenants as possible. And it created this Office of Civil Legal Aid, which is similar to what other jurisdictions do for implementation purposes. And also it just released an implementation plan. Connecticut is fully funded with fiscal recovery funds for the moment, but they do hope to get kind of additional funding. There was huge Democratic Socialists of America involvement in Connecticut, and that's also a right to counsel that is currently on the books in Connecticut. And then in Maryland, of course, there was unfortunately a problem with an accompanying bill that would have funded the right to counsel or access to counsel program in Maryland, and that failed to pass this past year. But there are, the right to counsel is on the books in Maryland. It's just now figuring out implementation, figuring out the funding kind of piece of it, which is a really, it's going to be a really interesting kind of work. There are over 50 jurisdictions that we are working with regard to the right to counsel in eviction proceedings. I listed these in particular, so Fresno, LA, and Houston, because they're doing some really interesting, they've passed some really interesting programs that are trying to get at a right to counsel eventually. And then there are also major kind of efforts that have happened in the past year and a half about at the federal level where representatives and senators have introduced legislation that would, in one way or another, either increase representation significantly for tenants facing eviction, or would support a right to counsel. All right, so just very quickly, a couple of updates in other subject areas, and then I think we have about 20 minutes left for questions and answers. Please correct me if I'm wrong, John and Kathleen. So in other subject areas, as I discussed kind of earlier, NCCRC, our focus right now is really housing-based and eviction-based, but we really work all kind of civil legal areas. So we really look at jurisdictions and where they're working on the right to counsel, what it is that they're doing with regard to a right to counsel. In Nevada recently passed legislation which guarantees the right to counsel for minors in domestic violence proceedings. In Arizona, there was recently Arizona passed legislation which established the right to counsel for children in child welfare cases, finally. The Supreme Court of Ohio recently found, at the end of 2020, found that indigent parents who are facing adoption also have a right to counsel under the Equal Protection Clause of Ohio's Constitution. In terms of litigation, since I've been here, we've been involved in 3 kind of cases where we've submitted amicus briefs. So in Hawaii, in 2014, there was a case which established the right to counsel for parents in child welfare proceedings, but there was some language in that court decision that made it really murky about when it is that counsel would be appointed. And we filed an amicus brief in, I believe, July or August of last year, 2020, and then received a decision this past March that really broadened the right to counsel to the stage of filing. So at the time that a child welfare case is filed, a parent is now appointed counsel in the state of Hawaii, where the state is seeking foster custody, which is amazing. They also decided that the failure to timely appoint counsel was reversible error, which was also a really great win. Just very recently, we submitted amicus briefs in Ohio about the right to counsel for children in child welfare and permanent custody proceedings. There, the standard is really severe for children to be appointed independent counsel. And so we submitted amicus briefing in support of the Supreme Court taking jurisdiction over the case and issuing basically a new standard for children to be appointed independent counsel. And then we also recently submitted amicus briefing in the state of Massachusetts with regard to domestic violence proceedings, arguing for the right to counsel or showing the Supreme Judicial Court there why they should establish the right to counsel for both plaintiffs and defendants in domestic violence proceedings, 209A proceedings in Massachusetts. That is really a rundown of the kind of broader subject areas that we work in. I know that there was a lot of focus on child welfare work. There's also a lot of interest and kind of work being done in the adult guardianship realm right now. And we're really excited about what kind of assistance we could offer there. I think that I've made it through at 10:06, and I will stop there because I'm really excited to hear questions and talk with you all some more.
Thank you, Maria. And if anybody has any questions, put them in the chat if you can, and I'll start with, there's a question from Ruth Johnson. So Ruth, if you're here and can unmute yourself, could you ask the question about the legal objections?
Yes, thank you. My name is Ruth, and I'm in a community where we have a right to counsel coalition, and we have a city council member who is willing to sponsor it. There's draft legislation. Where we're running into a problem is the city's attorney is of the opinion that using general funds, the city's general funds in a private dispute would violate our state constitution lending of credit clause. I believe this is a specious argument. We have provided counter legal opinions, and we may be seeking our state attorney general to issue an advisory opinion, but I'm just wondering if you could speak about some of the legal arguments, barriers, objections, and how they've been overcome.
Yeah, I mean, I think I wish I could touch more about the overcoming part of the legal objections that we're aware of and that we know of. Absolutely, Ruth. Absolutely, there are objections that are kind of brought up when we talk about the right to counsel for tenants, but also just the right to counsel kind of more broadly and in other civil legal areas. And those objections really run the gamut. They're really different depending on where the jurisdiction that we're working with is. So we've heard objections regarding home rule versus Dillon's rule, right? So the authority of a particular municipality to really establish a right to counsel is an objection that we've been kind of working through and trying to research more about. Those are generally the objections can be housed in this like idea of authority, whether a smaller jurisdiction like a city, a town, a county even has the authority to pass something like this. Some of the legal objections are really tied to the landlord-tenant laws, right? So thinking about whether the state has kind of full control over landlord-tenant laws in the state. Those are objections that we've kind of heard before. Again, I wish I could tell you more about the overcoming part of it. Unfortunately, it is really jurisdictionally based, and it has to do with what authority your jurisdiction has, what case law is on the books, what other kind of similar legislation has been passed, and what was the basis for that. But yes, there are going to be there's going to be opposition from the municipality with regard to establishing a right to counsel, for sure. In addition to opposition that's going to come from other kind of places too. Landlords are not necessarily fans. Courts are not necessarily fans of a right to counsel because it really impacts the way that the proceeding kind of glides through right now on its conveyor belt and implicates that for the courts and for the judges. A lot are supportive, but many are also wary about incorporating another attorney into the proceeding. So there's opposition at all levels, but I will tell you that there is also as far as the tenant right to counsel, there's a groundswell of support and kind of advocacy for it, and work and research looking at those oppositions and coming up with counter arguments. I'm really happy to hear that you were able to come up with some for your jurisdiction.
Maria, there's a question from Elizabeth Green that actually you just touched on by mentioning the judiciary is sometimes, in some ways they're supportive, in other ways they're in opposition, and partly because it just throwing more lawyers in makes the case take longer. Instead of having a 2-minute eviction case, you now have to listen to arguments from both sides, and that might take 10 minutes. What about the number of judges to hear cases? In any jurisdiction, has a right to counsel also spawned kind of increased judicial resources?
I mean, I think I could talk as far as like changing the way that the housing court or judiciary works. New York City is a really great example of the way that it was functioning, and then the way that it kind of functions now seems to be working a bit better for tenants facing eviction. So there have been changes to housing court in New York City as a result of the right to counsel kind of passage there. But yes. So those are all of the practical kind of implementation pieces that come along with the right to counsel. It's not just it can't just function as this right that exists on the books. It actually has to change the way that we've been doing eviction proceedings. That includes changing the way that judges and how many judges are there to hear cases, maybe changing the way the structure of the court itself, like establishing a housing court rather than having evictions go through the small claims court as they do in some jurisdictions. So yes, there are implementations and kind of practical changes that have to take place. I want to combine kind of Elizabeth and Ruth's question a bit and just touch on, when we were writing an amicus brief in Massachusetts, there was this kind of consistently repeated idea that we can't consider really, and we shouldn't, the practical effects of establishing a right to counsel when it is a right to counsel. So in that regard, it was a constitutional right to counsel. It had to do with fundamental rights, which can be argued definitely for right to counsel in eviction proceedings, but hasn't been really done that way. But it's this idea that things are going to change. They have to change because of the right to counsel, including the way that the state decides it's going to invest its money and use its money. Those things are going to change, but the benefits that result from representation are just too immense to kind of overlook. So we have to really understand that the changes will happen to our judiciary and to other functions, to other bodies in our jurisdictions, but that the benefits really overwhelm that concern.
Neil Law, you just asked a question about where implementation has already taken effect. Who are the attorneys who are appointed? Is it a panel? Is it through an agency? What's been the structure of, or the organizational structure of the lawyers who are now being appointed?
Yeah, that's a really good question. Because that actually touches on the other two questions, is that's also a really big concern, is that it changes legal aid kind of services and providers and the attorneys that we use to serve folks. So there's a number of ways and a number of kind of issues that come up when a question like that is asked, and I'll touch on a few of them. So the ordinances and local laws that have already kind of passed, are already on the books in the 14 jurisdictions, they all have, they touch on kind of implementation. Typically, it'll be something like designing an Office of Civil Justice, for instance, or creating some kind of agency in order to coordinate the right to counsel. But ultimately, there is a provider that is incorporated into the law somehow. And it could be a legal aid, legal services provider. Sometimes pro bono attorneys might be incorporated into the kind of the structure of the program. But typically it's going to be the local legal aid provider that's going to get an increase of funding such that they can hire and really do the work that they are so amazing at doing when they can do it, when the resources are there and capacity is there. These are some of the most competent attorneys with regard to eviction proceedings. And so it makes a lot of sense that they become the designated kind of providers that are incorporated into the ordinances. So typically it's going to be the legal aid provider actually doing the representation, with a little bit of discretion as to, I think, as to, in some ordinances, whether they have to provide the full scope representation or whether they can just do advice and counsel, depending on eligibility. In New York City, for instance, if you're income eligible, you have the right to counsel. If you're not income eligible, you still have a right to some advice and some counsel from an attorney at the day of the proceeding, but not necessarily any representation if you're not income eligible. And so there's really differences in the way that that's structured. The one main thing is that, and it hasn't really been incorporated into the ordinances to a great degree, but should be, is that attorneys who represent people in eviction proceedings need to be very competent in these proceedings. They can be really complicated, case law ridden kind of cases, civil proceedings. And so those attorneys we should be incorporating funding in order to make sure that they are trained, that they are supported, that the caseloads are not enormous, such that they can offer the best possible representation possible to tenants who are facing eviction. Because eviction is such a crisis for the tenant, because it's such a crisis for the client, we don't also want to create a crisis for the legal aid provider to be in crisis serving a person who is also in crisis. I mean, those are kind of implementation issues that are just starting to really roll, and that we're all starting to kind of meet around and talk about, because they're going to be really important. And it's really important to figure out, who are the lawyers that you are hiring, and who is representing community members, and are they part of the community? All of those questions are really important about who are the actual lawyers doing the work. One other note, rural communities are having such a hard time. They want to be doing something like this. They want to establish a right to counsel, but we're hearing over and over that it's so difficult with the way that the funding is set up for legal aid providers, and the way that they pay attorneys. It's really difficult to find attorneys to actually do this work, whether they want to or not. It's just, it comes down to the ability to fund, to pay people to kind of move into those areas and help and assist. So lots of issues. I just touched on just a few of them, but yeah, those are really major thoughts that we're having too.
I'm wondering, just as a follow-up, New York City, I guess, probably had the greatest head start on this. Do you know, like, what percentage of attorneys has it doubled the number of attorneys? Like, how many, and how many years has it taken now to ramp up? Are they there yet?
Yeah, so I'm going to address those a little bit separately. So I think that the number of attorneys might be contained. I don't actually know the statistic off the top of my head. I think it is being monitored because there is an Office of Civil Justice and a coordinator that runs the program. So they're kind of aware of what it is, what's happening there. So that's one portion. I'm sure that there is a number out there, John. I can't give it to you. But as far as, yes, so the legislation passed in 2017, and it was going to be on this, I think, 4 to 5 year plan, so phase-in plan, and it was dependent on zip code. So where there were really high rates of eviction, they were going zip code by zip code and kind of ramping up the attorneys that were providing services there and representation in those zip codes. Because of the pandemic, they were able to pass through, I don't remember if it's an amendment to the original legislation or if it's a new local law that was passed, but it changed the way that the right to counsel in New York City works, such that now it's just being implemented across the city. And so kind of legal aid providers are trying to figure out how to do that. Yeah.
Okay.
But New York City has been really, I mean, I'm positive that there are problems, but they've funded the right to counsel. They've been providing the funding to make sure that people have representation in eviction proceedings. And it's, kind of stating what their value is, what the value is of the right to counsel for them.
Mm-hmm. Other
I haven't talked this long in so long.
Okay. Other questions?
If there aren't, are there any, John, that you see?
No.
If there aren't any questions, I mean, what I would really recommend, if you're interested in this, there's stuff happening all the time. I mean, you'll find, Washington Post articles about it. There's a lot being written about it. I really recommend, if you want to be kind of inspired or you want to see what took place on the ground, how the right to counsel is viewed by community organizers and how it's viewed as a change in power, how it presents, like a change in dynamics in eviction proceedings and really is about power, how eviction proceedings are about power, and also how the right to counsel can empower tenants. I would recommend watching the documentary from RTC NYC Coalition. They produced it. It's on their website. It's really easy to kind of find, short, but really interesting and about this exact kind of moment.
Okay, well, thank you very much, Maria. We're getting near the end of time, so I think we'll let everyone finish their breakfast and go to work.
Yeah.
But we appreciate you being here, and and everybody who is in the audience, we appreciate you being here.
Yes,
so thank you all.
So much. Thank you, everyone.
Bye-bye.